Thank you very much, Ovidio. And we'll proceed to the third presentation, third paper of this session by Dr. Meir Bnaya, who is the head or chief historian at the Holocaust Survivors' Rights Authority of the Ministry of Social Equality in Israel. He received his PhD from Tel Aviv University, so here on this premise, in Jewish modern history. He's the author of the book Moshe Almoznino of Salonika, which was published by Tel Aviv University in 1996. He published recently A Philosopher in the Stock Market, Ethics and Capitalism in 17th Century Amsterdam in Joseph Penzo de la Vega, Confusión de Confusiones. Was published in Studia Rosentaliana, where I'm also on the editorial board. So he will talk on a shorter topic, Holocaust compensation for North African and Middle Eastern Jews. The title is shorter. We'll see if the presentation will be short. Okay.
Dear Professor Mechman and colleagues, dear guests here with us and online. The increasingly widespread idea that the limits of the Shoah transcend the borders of Europe has raised the awareness of non-European communities in Israel to the possibility of claiming benefits from the State of Israel pursuant to the person disabled by Nazi persecution law from 1957. The purpose of this lecture is to present key historical considerations that emerged in the complex process that eventually led to the recognition of citizens from Tunisia and Libya under the terms defined by the 1957 law, while rejecting the claims of citizens from Morocco and Iraq by both the government and the Supreme Court. I have a few preliminary comments. I am aware that my talk is related to one of the most sensitive issues in our society. That's why it's important to define the context of my lecture. The context was well phrased by the Honorable Judge Daphna Barak-Erez at the beginning of the Supreme Court. It's okay. The context was well phrased by the Honorable Judge Daphna Barak-Erez at the beginning of the Supreme Court's decision concerning the Farud. I quote, "The question presented to us does not pertain to recognition of the victims' unbearable pain or the fact that they were victims of terrible hatred and incitement. It also does not relate to the place of the Farud in the national story of Jewish persecution in the Diaspora in modern times, or to the memory of the Holocaust. These issues, with their undeniable significance, shall be left to the historians, sociologists, educators, and policymakers. We, however, are required to answer a different question, a narrow legal question. Are the Jews of Iraq who were victims of the Farud eligible for compensation under the terms of the 1957 law?" Unquote. I shall speak today not as an objective observer armed with a theoretical and critical apparatus, but rather as a historian on behalf of the Holocaust Survivors' Rights Authority, which took part with expert scholars and legal advisors in formulating the position of the state in these issues. So let's start with Iraq. In September 2009, Jews from Iraq began to file claims. The basic argument of Iraqi Jews was that the Farud on June 1 to 2, 41 was carried out under a Deutsche Veranlassung, namely instigated by Germany. The historical legal dispute centered on two main questions. What was the affiliation of Nazi Germany with Iraq at the time of the Farud? And what wage did German propaganda originating from Berlin bear on the executors of the pogrom? Iraqi Jews sought to prove that in April, May 41, during the reign of Rashid al-Khalani, Iraq was a type of satellite state of Germany. They emphasize the significance of Nazi propaganda originating from Berlin for Iraq and the affiliation with Germany and its anti-British elements. The representative of the state, in contrast, claimed that no link was formed via orders or instructions between Germany and Iraq during the rule of al-Khalani, not to mention previously or subsequently. They also claimed that the German propaganda was no more than a secondary cause among myriad old and new causes of the pogrom. They also claim that the German propaganda was no more than a secondary cause among myriad old and new causes of the pogrom, that German propaganda is not sufficient proof of a Deutsche Veranlassung over the Iraq regime. Moroccan Jews in Israel began to file claims in September 2012. The basic argument of Moroccan Jews was that from June 1940 to November 1942, the Vichy government had imposed on Moroccan Jews restriction as part of a policy resulting from the French process of surrender to Germany and from Germany instructions. In the legal debates conducted in the appeal committees, the historical disputes primarily address two questions. First, was Vichy France a satellite of Germany, or was Morocco under any German initiative, instruction, or compulsion? Second, the extent and meaning of the persecution of Moroccan Jews and whether it constitutes a deprivation of liberty or only restriction of liberty. The parties were also disputed regarding specific historical questions as the extent of Jewish dismissals from public service in Morocco and which cities were subject to the Dair, the Sultan order from August 22, 41, that forbade Jews lacking French citizenship who arrived in European quarters after September 1st, 39, from living or holding property there. Honorable Judge Aaron Sadeh, chairman of the appeal committee, summarized the debate in his decision. I quote, "Even if we accept the appellant's claim whereby it should be accepted that the Vichy regime indeed operated under German initiative, even then, Moroccan Jews cannot be recognized according to Section 43 of the German law, as Moroccan Jews themselves were not subjected to the privation of liberty as defined for the matter of eligibility for compensation. After reviewing the claims of Iraqis and Moroccans, the Holocaust Survivors' Rights Authority rejected them, and the appellants turned to appeal committees in Haifa and Beersheba simultaneously under the Person Disabled by Nazi Persecution Law of 1957. Ultimately, both appeal committees rejected the appeals of Iraqi and Moroccan Jews after they discussed in depth the evidence, expert opinions, and details inquiries presented to them. Finally, the Supreme Court as well rejected the appeal of by Iraq Jews on March 2019 and of Moroccan Jews on August 2091. 21. As a result, they were compelled to relinquish the monthly payment, a minimum amount of 2,500 Israeli shekel to a maximum of 11,000 Israeli shekel, and other benefits granted to those persecuted by the Nazis. On December 2015, in the midst of the discussions, the Minister of Finance reached an administrative decision constituting a type of recognition of the suffering undergone by victims of the Farud and of Moroccan and Algerian also Jews. The administrative decision recognized them as victims of anti-Semitic and racial harassment during the Second World War. Based on this decision, they are eligible for an annual grant of 6,500 Israeli shekel and free medication, requiring only a self-declaration. You can see the number of Iraqi, Moroccan, and Tunisian Jews among the presently recipients of an annual grant and free medication. There is no doubt that the struggle of the Jews of Iraq and Morocco was also about recognition. They wanted to obtain a symbolic achievement and not just a material one, as Joseph Brunner explained yesterday in another context. My impression is that some people are very disappointed with the results. They wanted everyone to recognize the importance of the Kristallnacht of the Iraqi Jews. Others received the annual grant and say to themselves, we are Holocaust survivors too, not only the Ashkenazim. Tunisia. The first claims by Tunisia were filed in 1996. Tunisian citizens of Israel who had immigrated to the country before October the 1st, 1953, and had been living in Tunisia during the German occupation from early November 42 to early May 43, are eligible for compensation from the State of Israel, similar to other Jews who had been within the territory of the Third Reich. But Israel did not see itself obligated to pay compensation to those Tunisian Jews who had foreign citizenship, French, Italian, or even Tunisian citizenship. as by virtue of this citizenship, they did not fit the BEG definition of persecuted persons. And therefore, it was not the reparation agreement, but rather their foreign citizenship that barred them from eligibility for German compensation. This obstacle was removed gradually following various court rulings, Zimbri, Khalifa, and Muscati. Hence, an administrative decision by the Minister of Finance again from 2014 determined that Holocaust survivor shall not be barred from recognition by law only due to his foreign citizenship, so long as he is not receiving compensation from that country. For 50 years, no law was legislated in Israel regarding the Holocaust survivors until the law of benefits to Holocaust survivors from 2007 was enacted. Based on this law, a Tunisian who arrived in Israel after October the 1st, 1953, and therefore the law from 1957 does not apply to him, could be recognized by declaring that he had been in a German camp in Tunisia or had accompanied one of his parents to a site where they performed hard labor for the Germans, or that his mother has been pregnant with him when she did hard labor. Those Tunisians who do not declare this are eligible only for annual grant and free medication. 6,000 Tunisians have received annual grant. Libya was the only country in North Africa that had been under Italian rule. But the massive military presence of the Wehrmacht in Libya, due to the war that took place in its territory between the British and the Germans, generated circumstances where Germany motivated Italy's policy concerning the Jews. Notably, Jews from Libya who had been in the Jado camp, where some 500 Jews died of typhus, were recognized in the 60s by the German under the BEG. This precedent was very important for the recognition of Libyan Jews by the State of Israel. In 1984, increased considerably the number of Libyans who filed claims. In the late 90s, the authority began a gradual process of expanding recognition of Libyan Jews. At first, deportation within Libya and outside Libya, as well as concentration and labor camps in Libya, were recognized. At this stage, the authorities still reject claims filed by Libyans who had fled to the village, mainly from the city of Tripoli, for fear of the Germans due to the Allied bombings. On April the 1st, 2010, the Taya ruling was the first to recognize the possibility of applying the rule of fear to Holocaust survivors from Libya. Following this ruling, in September 2010, those who had fled to the village for fear of the Germans were also recognized through an administrative decision by the Minister of finance. Notably, it was in this case, that the administrative decision device was utilized for the first time to expand the spheres of recognition to new groups of Holocaust survivors. This includes not only Jews from North Africa, but also from Romania and Bulgaria, as well as German residents who had previously been prevented from claiming recognition by Israel. You can see here updated data, the number of Tunisian and Libyans among the survivors presently having rights by Nazi persecution law from 1957. And now you can see the small number of Tunisians and Libyans among the survivors presently having rights according to the 2007 law. In conclusion, please look at the graph that represents the budget of the Holocaust Survivors' Rights Authority. A budget that has grown almost 4 times in the last 16 years indicates a change in the attitude of the State of Israel toward compensation. The process that eventually led to recognition of most Libyans and Tunisians was lengthy and took place in stages. In this respect, they were no different from other communities. A patchwork, as colleague Avital well defined this yesterday. This process was affected by court ruling from the 90s that led to the recognition of new ground for eligibility, such as certain types of deportation and curfew in Bulgaria and Romania. In the absence of any initiative by the legislators or government, these rulings are a manifestation of legal activism inspired by the 1992 Law of Human Dignity and Liberty. Against the background of important social process, the attitude of the court is, in my opinion, an important factor that paved the way for subsequent changes in the attitude of state authorities toward the issue of compensation for Holocaust survivors. Finally, I would like to thank my colleagues, expert scholars who contributed of their knowledge and took part on both sides in this important public debate. Thank you for your attention.